All right, folks, buckle up, because this courtroom moment is one wild ride. We're opening with Mr. Saylor, a man who starts off talking about vapes in jail before realizing he's facing a felony sex offense charge. Yeah, that's right, a gross sexual imposition case involving force. What makes this wild? He's halfway joking about smoking privileges, while the judge is confirming he's pleading guilty to a crime that could follow him for the rest of his life. But here's the twist, he doesn't even fully understand what he's pleading to. You can hear it in his voice, confusion, denial, and desperation all tangled together. The judge asks, "Do you understand you're pleading guilty to a felony sex offense?" And he replies, "Basically, kinda." That's not the confidence you want to see in a plea hearing. And as this continues, things get darker. Mental health, addiction, and a tragic past all come into play. So stay tuned, because this isn't just a legal breakdown. It's a psychological unraveling happening right in front of the bench. What would you do if you were this defendant? Take the plea and go home, or risk trial for your truth? Let's find out.
I would spend my jail time in Kentucky. At least I could smoke in jail. The vapes.
I have your. Okay. Mr. Saylor, tell me what you think is happening today, sir.
Taking a plea, I still don't understand the plea because it didn't happen that way. I didn't use force because when I walked by her car, she caught my eye because she was wearing bra, the bikini top and bottom. And I opened out the door, touched her butt, but I didn't pull down her shorts or put my hands up under her shorts. But I take the plea if it get me out of here faster. They could say whatever they want to, as long as I know the truth. Because my biggest thing is drugs. I love drugs, and I love my gun. When my gun got taken away in Kentucky, I lost my mind.
Okay, sounds like you're saying you understand what you're doing. You understand that you're pleading guilty to a felony sex offense involving force. Do you understand that?
Basically, kinda.
Okay, it sounds like you were denying the force part there to me. Do you understand that you're pleading guilty to a fourth-degree felony, which will be with you for the rest of your life, and you'll be required to register as a sex offender for how long?
Here's where the judge starts to get concerned, and honestly, rightfully so. The defendant says he'll take the plea just to get out faster, but in legal terms, that's a huge red flag. You never plead guilty to something you don't understand or admit to doing, especially a felony sex charge. The judge catches it immediately, and his story doesn't add up. On one hand, he says, "I didn't use force," but on the other, he's agreeing to a plea that specifically includes force. That's like saying, "I didn't steal, but I'll plead guilty to robbery if it gets me home." This is the gray area of justice where confusion meets consequence, and the judge is trying to stop him from making a life-changing mistake on record. Would you call this compassion from the bench or cautious professionalism?
How long on this?
15.
It's at tier 1, up to 15 years, Your Honor.
Okay, could be 10, could be 15, but it's up to 15 years.
Whatever to give back home to my family, whatever to see my family case. My mom and my dad loves me, and I got to be there for them because they're getting old.
Okay, here's what I need to make sure of, is that you understand what you're doing.
Not really,
Okay,
because sometimes I black out and I don't know what I'm doing. I didn't even know what I did until they told me when I got to the jail that day. And it
Okay.
was on my brother's birthday.
He's trying to see if you know what you're doing today as far as taking a plea instead of sitting in the 12 hours.
Oh, okay, yeah, I understand what's going on today.
tell me what's going on today.
Taking a plea instead of taking it to trial.
Right, that's right. And that means you admit to doing this.
Yes.
Okay, and you admit to not only touching, which would be sexual imposition, you admit to touching by force, which is gross sexual imposition.
I didn't admit to that, but I admit to the other one. But they could say that to get me out of here today.
Well, we can have a trial too.
I don't want to have a trial because it'd be less time more time in jail.
Not necessarily. You could go to prison for 18 months on this charge. If you're found guilty of this charge, you could go to prison for 18 months. Do you understand that?
Yes, sir.
Okay.
Do my jail time counts too?
Yeah, your jail time counts too, but I want to make sure you understand that you could go to jail, you could go to prison for 18 months, and you're pleading guilty to something that you say you didn't do. So there's a little bit of a discrepancy there. Now, if you've talked to your attorney and you feel that the act you committed was done with force, then you understand what's going on. But if you're standing here and denying any force to me, I have a problem with that.
Yes, sir.
Yes, what? You understand what I'm saying?
Meds and reveals a horrific childhood trauma, being abused in foster care. You can feel the energy change. The room goes quiet. The judge listens carefully but stays within legal boundaries. And here's the legal insight. Mental health and competency are not the same thing. Someone can have severe trauma or mental illness and still be legally competent to stand trial, meaning they understand what's happening and can help their attorney. It's heartbreaking, but the justice system can't pause every case for personal tragedy. The courtroom has to balance empathy with process, and that's now the entire courtroom tone shifts. When the defendant starts talking about not being on is exactly what's happening here,
I basically understand what you're saying in some kind of way, but in other ways I don't really know what's going on because I ain't on the right meds like I'm supposed to be on. And when I was a kid, they put me in foster care and I got raped by full-grown men and full-grown women when I was a kid.
Okay. That's a traumatic experience that I assume you discussed with the people who at Summit who evaluated you.
I want to talk about that to them because they asked my family commit suicide, and I stopped talking to them. I stopped seeing that lady, Cammy, and she came in, done another post and came and done another interview, and I didn't understand. They just asked if we knew something about trial and stuff. But the first doctor, Dr. O'Donnell, was asking me if I had anybody in my family commit suicide and stuff. Yes, but I didn't tell her that. And when I don't get my way or whatever, if you look at my arms, you can see I'm a big cutter.
Okay. Mr. Statement, why is he pleading guilty to this offense?
Your Honor, my client is adamant that he does not want to go to trial in this matter. And that's the discussion we've been having.
But he's denying
the force aspect, yes.
Okay.
And my recommendation would be set it for a bench trial.
Well, this doesn't appear to be your recommendation.
But my client is adamant he does not want to go to trial. He wants to accept a plea. Is that right?
Yes, so to get up out of here and get a treatment program because I am very addicted to drugs.
Okay. Okay.
this is one of the most frustrating yet powerful parts of the hearing. The defendant's attorney tries to explain. His client doesn't want a trial, even though he denies using force. And the judge's face says it all. You can't have both. Here's the law in play. For a plea to be accepted, it has to be knowing, voluntary, and factual. If the defendant keeps denying part of the charge, the judge literally can't accept it. Otherwise, it risks being overturned later as an invalid plea. So when the judge says, You're saying two different things. That's not just confusion, it's a legal contradiction. And when the defendant finally says, I take it to trial then, it's both relief and chaos in one moment. He doesn't realize it, but that one line just changed everything.
Pleading guilty to something doesn't guarantee you'll get a treatment program. I'm more hung up on this fact that you deny that there was force involved. Now, if you have a trial and it turns out that it was, you're not going to be punished more just because you had a trial. If you plead guilty and you're saying, I accept responsibility, I did this, I did it by force, which makes it a felony, that's fine too. But you're saying two different things. You're saying, I touched her, I didn't use any force, and I just want to get this over with. But that's not going to get it because you're going to regret it in the future, if that's the case.
I take it to trial then,
Okay.
because I still don't understand what's going on.
Okay, well, you seem to have a good understanding of what's going on. The problem is you're saying some things that are contradictory, meaning you're saying one thing and then you're saying another. That's the exact opposite. So
Now we move into the competency phase, and this is where the psychology meets the law. The judge references Dr. Nick's report, confirming that Mr. Saylor is competent to stand trial. That means he understands his charges, the process, and can assist his lawyer. Even though he's admitted to mental struggles, self-harm, and confusion, the bar for competency isn't perfection. It's basic comprehension. Notice how carefully the judge explains it. You can agree you're competent, or your attorney can ask for a second opinion. That's her ensuring he has every fair chance. But deep down, she knows the man understands enough. The case must move forward. And here's a thought for you. Should the law be stricter or more forgiving when mental health clouds understanding?
So set it for trial.
Very good.
Bench trial.
Hold on, but we still have the competency issue. Are we stipulating to the
I'm
competency
sorry, I kinda
report?
skipped-
I thought, I just want to make sure
Yeah.
we've done that first.
Okay, let's talk about that. You have been determined to be competent to stand trial, meaning you understand the charges against you and you understand enough to assist your attorney in defending you in this case. You had two choices. You can agree, yes, I'm competent, or you can say, no, I'm not, and your attorney can request a second opinion. The second opinion may very well say the same thing because you seem to understand what you're doing. Your attorney's saying, we agree Mr. Saylor is competent. He understands what's going on and he understands enough to help me defend him. Do you understand that?
Yes, Your Honor.
Okay. Do you believe that's true?
Yes.
Okay. Then I'm going to make a finding that he's competent based upon Dr. Nick Stein's report. She's a very qualified psychologist, and she's made a determination that you've been at Summit long enough. They helped you understand how to participate in a trial. So we're going to go to trial in the case, and I don't know what the outcome will be, but it's not going to be any worse. You're not going to be punished for exercising your right to have a trial.
And my jail time accounts into my sentencing too?
You already asked me that. Do you remember asking me that a few minutes ago?
No.
Okay. Yes. Yeah, for all the time that you serve in jail on this case, you get credit for that. If you're found guilty and you're sentenced, you'll get credit for that as a part of the sentence.
Either way, if I take it to trial or take a plea, it's 18 months. I got to spend
That's
in
the
jail.
maximum you could get.
Here's where the courtroom unexpectedly lightens, and it's almost surreal. The defendant starts talking about smoking vapes in Kentucky jail and asking if his old handgun case can send him back. Even the judge cracks a subtle joke saying, "You know why you can smoke in Kentucky? Because tobacco's their main crop." It's a rare human moment in a heavy hearing, but legally it shows something deeper. His mind keeps drifting away from the gravity of the situation. He's focusing on comfort instead of consequence. The tension, humor, and confusion here all blend into one of the most bizarre yet honest moments in a courtroom. A man lost between addiction, trauma, and reality.
It doesn't mean you'll get 18 months. I just want to make sure you understand you could get 18 months. Either way. Either way. Do you understand that?
Oh, yes, so I don't really want this on my record because I got enough felonies on my record, and I don't want this on my record.
Okay, well, I don't blame you. If you're found guilty, it will be on your record. And if you're found not guilty, it won't be on your record.
Because Kentucky, they dismissed a handgun case, and can Kentucky pick up my handgun case and send me back over to Kentucky? Because I would rather spend my jail time in Kentucky. At least I could smoke in jail. The vapes.
You know why you can smoke in jail in Kentucky? Because tobacco's their main crop. Okay.
Hell, a pot is that us main crop.
Well, it may be.
I'm a big pothead.
I can't advise you on Kentucky. If they dismiss the charge, it's dismissed. That's where it stands. I can't predict the future. And this trial is not going to affect what they do, to my knowledge.
Okay.
Ms. Hyatt, how many witnesses do you have?
I will have approximately, let's get to that, I'm sorry.
Did you say 4?
I would say 3 to 4.
Okay.
I don't anticipate any for the defense, Your Honor.
Okay. All right, so this is a one-day trial at the most.
Now, the case edges closer to a real decision. The judge and attorneys discuss jury trial versus bench trial, and this is crucial. In a jury trial, 12 people must all agree beyond a reasonable doubt. In a bench trial, just the judge decides. The defendant picks the judge, saying she might understand his mental health better. That's both touching and risky. A jury might be unpredictable, but with one judge, there's zero room for emotional sway. Still, the judge takes time to explain every option, showing real professionalism. She doesn't pressure him, she educates him. And that's what separates a good courtroom from a chaotic one. What would you pick? 12 jurors, or one judge deciding your fate?
The most. Maybe a half day.
Mm-hmm.
Okay.
My mom and my dad was there. They was calling my name, but they didn't know where I was at. They thought I was in the bushes taking a shit. But I went to the bathroom at the store.
All right, hold on, don't tell them things.
Are we waiving jury, Your Honor?
Or
are we having the jury trial?
We've got to do that. There's 2 types of trials you can have. One is a trial to me. The other is a trial to a jury of 12 people. You have a right to have either. If you have a jury trial, all 12 people on that jury have to agree you've been proven guilty beyond a reasonable doubt. All 12 people have to decide that before you can be convicted. If you have a trial to the judge, it's just one person who makes that decision. In this case, that would be me. So if you want a jury trial, you can have a jury trial too.
I take a bench trial.
Okay.
I don't got no clothes what I could wear to a trial.
Oh, you can have clothes. We can get you clothes. Mr. Staten, have you talked to him about the difference in a jury trial?
We did, Your Honor, briefly, but as I said, he was adamant he did not at that time want to do a trial of either type.
Okay, why don't you talk to him a few minutes back there?
If I could.
He may be better off with the jury. I don't know, but at least
Sure.
I want him to understand the difference.
Absolutely.
Okay, thank you. All right, you've had some time to speak with Mr. Saylor. Do you prefer a jury trial or a bench trial?
A bench trial, Your Honor.
Okay. All right, sir, you have a right to a trial by a jury of 12 people. And a jury trial may be better for you because some jurors might not find this to be extremely serious, but if they follow the law and the elements are met, they also can convict you. But it would take all 12 of those jurors to agree before you could be convicted. If you tried to me, it's just one person who makes the decision. Do you understand that?
Yes, sir.
Okay.
And that one come I pick you because you might understand my mental health issue and stuff like that.
Well, that's a good point.
Like, I got color vision. I can remember some parts about the accident, but I can't remember all of it. I can remember walking by, stopping, light up my cigarette, and I saw.
Okay, but don't need to tell them right now.
Okay,
So you want to try it just to me.
yeah,
Okay, you understand that.
yeah,
Okay, seems like that's your desire. It's what you want to do.
yeah.
Okay. All right, set it for a bench trial then.
We have a to-be tried date, Your Honor, if he's found competent today, of November 21st, just so you know.
Okay, what are his living arrangements?
That's, I think, one of the issues, because his family's not here.
And they're out of state.
Okay, we will make time for a half-day bench trial. If you have any trouble setting this with Bethany, check with me because we can set it on a Friday, which we normally don't, unless the case it goes Thursday, Friday, but we could do that. So we'll figure this out.
Oh, y'all want my mom's, my sister's phone number?
I'm sorry,
Y'all want my mom's, my sister's phone number?
for what?
Well,
I'll call them.
okay,
I'll call them, Ken.
to let them know what's happening.
Okay, yeah, your attorney will take care of that for you.
Okay,
I got them. 256-298-2941.
yeah, and my sister's phone number is 256-977-3657.
That's the sister. Okay.
Yeah, Jennifer.
All right. Well, we're going to get this as soon as we can, as soon as the judge can. I got it. Thank you, Your Honor.
Yes, sir.
And there it is. After all the confusion, confessions, and contradictions, the court officially sets Mr. Saylor's case for a bench trial. The judge confirms he's competent, his rights are intact, and he'll face his fate before her, not a jury. This hearing captures everything that makes courtroom reality so gripping: raw humanity, painful honesty, and the thin line between understanding and accountability. Mr. Saylor isn't your typical defendant. He's a man caught between addiction, trauma, and a justice system that can't pause for emotion. But now his future rests entirely in the judge's hands. Will compassion or conviction win out? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns, where every case tells a story far bigger than the verdict.